Welcome to this rapid revision session of criminal law. Today we will have a rapid revision of non-fatal offences against a person. I'm Barrister Sadan Dalif. I'm a barrister of the Honourable Society of Lincoln's Inn and a full-time faculty member of Cambridge Business and Law Academy. The way I'm going to structure this rapid revision session is to start by giving you an idea about the non-fatal offences, and then I will go through each of the offenses in turn. So if you follow the slide here, you will find that we have 5 kinds of offenses considered as the non-fatal offenses against a person. Non-fatal offenses against a person are a mixture of both common law offenses and statutory offenses. And if you see on the slide here, we'll find that assault and battery both are common law offenses, and then on the bottom you'll find that GBH with intent contrary to section 18 of the Offences Against the Persons Act, GBH contrary to section 20 of the Offences Against the Persons Act, and assault occasioning actual bodily harm contrary to section 47 of the Offences Against the Persons Act. All of these three are statutory offences. If you consider these offences basing on the severity, then you will find that assault and battery are the least serious offences considered as non-fatal offences. And GBH with intent is the most severe offence considered as a non-fatal offence, and then it comes GBH contrary to section 20, which is less serious than section 18, and then it comes assault occasioning actual bodily harm, which is the less serious than section 20 of the Offences Against the Persons Act. So if you consider the offences basing on its severity, then you will find the least as GBH with intent contrary to section 18, then GBH contrary to section 20, assault occasioning actual bodily harm contrary to section 47, and then battery and assault. So firstly, we will consider assault, which is the least serious non-fatal offense. Assault is defined as where defendant does an act which causes the victim to apprehend imminent unlawful personal violence. For assault and for any other kind of non-fatal offenses, and for any other kind of offenses as well, the first thing you should do after considering the definition, you should distill the actus reus and the mens rea from that definition. And you will find that the actus reus of an assault is defendant caused victim to apprehend imminent unlawful force. If we consider this actus reus or break down its element, then we will find that the first thing we should consider is that the force must be unlawful. So if the defendant does an assault and then it comes to the court, it appears before the court that it was done under self-defense, then the force which was applied will be considered as lawful and no assault will be considered as occurred. The second thing under the actus reus element of an assault which you should consider is that words are enough for constituting an assault. And for these, we should look at R versus Ireland and R versus Barstow. The legal principle in both of these cases were that what matters is that defendant caused victim to apprehend imminent harm, and how the fear was created is immaterial. So the fear can be created by words, it can be created by silent telephone calls as well, it can be created by distributing offensive words or send notes, or it can be as well comes from silent telephone call, which we have already considered. So if we consider the fact of both of these cases, we'll find in the Ireland case that defendant made a large number of telephone calls to three victims, and in all the times he remained silent. But this caused the victim to suffer recognized psychological damage. And I repeat, recognized psychological damage. This is considered as a harm, and you are very new for this concept, but we will go through this within like 15 minutes when we consider this case on the on our next part of the presentation. But you must bear in mind that on Ireland versus Bristow, basing on this fact, it was said that silent telephone call can constitute an assault if it has the effect of causing the victim to apprehend imminent unlawful force. And if you consider the Bristow case, you will find that the defendant harassed his ex-girlfriend for a period of 8 months, and during this 8 months he sent this offensive cards. He take photograph of the girl when he saw her on the street, and as well he made silent telephone calls. Altogether, all these works, all these acts caused the victim to apprehend imminent unlawful force, and the harm which was suffered by the victim was depressive illness. And as a result, the divisional court said that there was an assault. So if we consider the House of Lords judgment in both of these cases, which was presided by Lord Steyn, we'll find that assault can be committed by words, gesture alone, and even by silent telephone calls as well. Now we'll consider another case, Constanza, where it said that defendant doesn't need to make silent telephone calls. Even writing can be enough for constituting an assault if it has the immediacy requirement which is required under the Actus Reus as well. In Constanza, defendant harassed an ex-colleague over a period of 20 months, and he sent over 800 threatening letters as well, which caused the victim to suffer recognized psychiatric illness. And as a result, what the Court of Appeal said was that the defendant did an assault. So from the Constanza case, which principle you should follow is that writing can be enough if it has the immediacy requirement required by the Actus Reus of an assault. So what the victim should apprehend? The answer is that victim should apprehend force. That force, unlawful force, will be applied on him. So for this, hearing order suggests that apprehension of touching is enough. So the force for touching is required and it must be unlawful. And there is no need of proving that defendant was going to actually carry out the threat, which we will look at which we'll look at in a few seconds, and then we'll consider the imminent requirement firstly. So under the imminent requirement, you should bear in mind that imminent is the alternative word for immediate, and in Ireland and Bristow, the court said that it is enough that a fear of immediate violence is amongst victims' fear. For this, it must be bear in mind that a threat of distance violence is not enough. If we now consider the case of Lugden versus DPP, and what I have said you earlier, defendant doesn't have to actually carry out the threat. We'll find that in that case, defendant showed victim a gun and told him he was his hostage. Defendant argued that he did not intend to carry out the threat and that the gun was fake. But the divisional court in that case said that conviction should be upheld because the defendant had created a fear of violence in victim's mind, and defendant does not have to actually carry out the threat as well. So the defendant cannot argue that this was a replica gun and I was not going to shoot you, or there was no way I would be able to shoot you. But the thing is that there is the apprehension requirement, which is the crucial part, and the apprehension must be occurred on the victim's mind. And the defendant work, it doesn't matter whether he has a replica gun in hand, it doesn't matter whether he has no bullets on the gun as well. But you'll find a specific activity on the subject guide which says you that if the victim knows that the gun is not loaded or there was no bullet on the gun, then your answer will be there's no assault. The reason behind this is that if the victim knows that there is no bullet on the gun, then there is no point of apprehending of unlawful force. And then we will see the point of like conditional assault. And the law regarding this is, if you consider the House of Law's judgment on the Tuberville versus Savage, and then the new judgment which have arrived on 2016 and 17, you will find that this area of law is unresolved. And I will not I will not discuss it uh, in this rapid revision session, but I will tell you the important pearls, what you should at least bear in mind for your July 2020 exam. You should bear in mind that if the condition is which was used by the defendant is like that, I will I will inflict harm on you if you don't do this, then this is expressing the positive intention of the defendant, and this will compel the victim to do a specific thing, otherwise the defendant will inflict harm on him. For example, you can take apologize or I will punch you. So in this sentence, that what the defendant is trying to say is that you should apologize or otherwise I will punch you. So in this kind of words, in this kind of sentence use, you should bear in mind that there is clearly an assault because it will cause apprehension on the victim's mind. But compare this sentence with what happened in Tuberville versus Savage. In that case, the defendant was holding a sword and he said that if it were not SSS time, I would not have taken such word from you. And on that specific time which occurred on that case, clearly it was the SSS time. So the victim was sure that the defendant will not cause any harm to him. So here the words negate the threat and the victim knew he would not be stabbed because it was SSS time. So the word had the effect of negate a threat, so it is not an assault. You should be able to compare these two types of cases on your exam. The next thing we will consider here is battery. And for battery, if we distill the actus reus and the mens rea from the definition, we will find that the actus reus of battery is that defendant touched or defendant applied force to victim. And the mens rea is that defendant intended or was reckless as to touching or applying force to victim. The first thing you should bear in mind for the actus reus requirement of the battery is that a battery can be carried out through an object. So what happened in the Fagan case was that defendant drove his car onto a policeman's foot and left it there. The divisional code said that in that specific scenario, the defendant had a duty to remove that car, which he didn't. And as a result, a battery has occurred. So, battery can be carried out through an object, and it can as well say from this case that battery can be committed by omission. Unlike assault, batteries can be committed by omission according to the case of DPP versus Santana Bermudez. The reason behind this is that when we first consider the definition of assault, we see that assault requires an act. So the definition tells us defendant does an act which causes the victim to apprehend. So here for assault, the defendant need to do something. But for battery, battery can be committed by omission, and for this we should consider the case of Santana Bermudez. What happened in that case was defendant was asked by a police officer whether he had on him any sharp objects. In that case, the defendant has a needle in his pocket, and he didn't take any kind of initiative to tell the police officer that I have a needle in my pocket, so you should not search me, or it will be very harmful for you if you search me. He didn't take this kind of initiative, and as a result, the court said that there was a battery where someone by act or word or combination of both creates a danger and thereby exposes another to a reasonably foreseeable risk of injury which materializes, there is an evidential basis for the actus reus of an assault occasioning actual bodily harm. So here, what happened was an assault occasioning actual bodily harm contrary to section 47, but for establishing that, firstly we need to establish that a battery has been occurred, and which was clearly satisfied in this case because this battery in this specific case occurred by omission. So when on the first place the defendant didn't take the initiative to tell the police officer that I have a needle in my pocket, the defendant was under a positive duty to at least make the police officer aware of the danger. As he didn't do this, the court and the divisional court said that there was a battery. So, as you have considered the DPP versus Santana Bermudez case and as well the definition of battery, you will find the difference that battery can be committed by omission and assault cannot. So, does battery require the application of force? What kind of force this must be? Whether it should be a direct force, like it's like a punch or something like that, or the defendant need to slap the victim, or it can be an indirect force as well. So the court said, mainly Perker Justice, Lord Justice says in the court of appeal that indirect force is sufficient for constituting a battery. If you consider the case of DPP versus K, we will find that a 15 years old schoolboy placed some acid he had stolen from a chemistry lesson into a hand dryer. And then when he suspected that any other student was coming towards the toilet, what he did, he left the sulfuric acid on the hand dryer, and then that another boy, our victim, he went to the toilet, and when he pushed the on button on the hand dryer, what happened is that the acid, it falls over on his mouth, and as well it damaged his skin. So Perker Justice said placing the acid in the dryer was reckless, so defendant was guilty when the injury was caused, and it was immaterial that the boy had not directly applied the acid to his victim. So what we can find from this case, the DPP versus K, is that assault like battery require not only direct force, but it can be committed by indirect force as well. Here comes the point, which is very interesting, is that can everyday touching amounts to battery? Our answer will be no, because in everyday touching there operates implied consent. The reason behind this is that if everyday touching was termed as unlawful, then it will be like very unwise to suggest that if you put forward your hand to your friend to do a handshake, then he can say he was trying to do battery on me, or I become apprehended, so there occurred an assault. But the thing is that the answer is no. So everyday touching cannot amount to battery. if we consider the case of Collins versus Wilcock, we will find the distinction between everyday touching and a touching which we require for satisfying the requirement, the actus reus requirement of battery. In Collins versus Wilcock, a policewoman took hold of a woman's arm to stop her walking off when she was questioning her. In that case, the woman scratched the policewoman and was charged with assaulting a police officer in the course of her duty, which is an offense under the Public Order Act. Here, what the Court of Appeal said is that when the police officer touched that woman, the suspected criminal, the police officer did the battery because it was unwanted touching, because you can find that it's not the same scenario as you approach your hand to do a handshake with your friend. But in this scenario, that victim, the woman, he didn't know what he did, and when the police officer approached to her and he was trying to stop that woman, he became apprehended. And for this, after the police officer touched the woman, then we can say that they constituted the battery. And what the woman did for self-defense. So defendant action was therefore in self-defense and her conviction was quashed. Implied consent existed where there was jostling in crowded places, handshake, backslapping, tapping to gain attention, provided no more force was used than is reasonably necessary in the circumstances. So don't hold your friend's arm too hard, otherwise he will lose a litigation against you and he will try to charge you for battery. Now we will consider the mens rea of both of these offenses together, and we will see the lot of differences between the mens rea of these offenses, because on the Wilson's book it's very confusing. It's more than 15 or 20 pages where he said that what should be the intention or what should be the recklessness which we need for establishing assault or battery. And sometimes on the cases, the judges refer these as the same requirement, but all those cases occurred before 1700. So if we consider the modern law, we will find that the mens rea requirement of an assault is that defendant intended or was at least reckless subjectively that victim would apprehend imminent unlawful force. So here the defendant must have an intention, or he should be subjectively reckless that victim would apprehend. But what is the difference? This type of mens rea of the offenses is that battery requires the defendant have the intention, or the defendant at least should have the defendant should be reckless subjectively as to touching or applying force. So for mens rea requirement of the assault, you need that defendant intended or was reckless as to apprehend the victim. But for battery, what we need is that defendant intended or was at least reckless as to touching or applying force. So here this is the slightest difference between these two mens rea requirement, and you can see that from the slide here, the mens rea of the two offenses are not interchangeable. So if defendant approach a sleeping victim intending to touch them, but victim wakes up and runs away, suffering actus reus of an assault, defendant is not guilty because he intended an assault but committed a battery. Here we say that defendant is not guilty. Defendant is not guilty for battery, but here the defendant is guilty for assaulting that victim. So you should bear in mind that this kind of act causes apprehension on the mind of the victim, and as the defendant has an intention to cause this kind of apprehension, at least if he don't have the intention, he has at least he was subjectively reckless to cause this kind of apprehension on victim's mind of inflicting force, So here the liability will be for assault. But the thing is that if the touching it occurred in this present scenario, then what you should suggest? You should suggest that there is a battery, because defendant had the intention, direct intention, that he wants to touch the victim and touching occurred. So for this, we can say that the actus reus and the mens rea requirement both are satisfied, and the defendant will be liable for constituting battery. So here's everything for the common assault, or if we break down the common assault, it's a battery and assault. And you should bear in mind that battery and assault both are common law offenses, even if the punishment for both of these offenses is prescribed in section 39 of the Criminal Justice and Court Act, but it all the definition and all the requirement for establishing actus reus and mens rea are provided on the common law. So widely it is accepted that these two types of offenses under the non-fatal offenses should be considered as common law offenses. Now we'll look at assault occasioning actually bodily harm. So depending on the severity, this is the third less serious offense considered as a non-fatal offenses. So you should bear in mind that this is a statutory offense considered under section 47 of the Offences Against the Persons Act, and section 47 say that whosoever shall be convicted upon an indictment of any assault occasioning actual bodily harm shall be liable to imprisonment for a term not exceeding 5 years. If we now try to distill the actus reus and mens rea from this section, we will find that the actus reus is that defendant must commit assault or battery and which causes victim to suffer actual bodily harm. And the mens rea is that defendant must intend or at least be subjectively reckless as to assault or battery. So you should bear in mind that for constituting a crime under section 47, the first thing you should do is you must do an assault or a battery. So both the actus reus and the mens rea of of assault or battery should be satisfied. And then from the assault or battery, it must be established that your assault causes the actual bodily harm. So you can consider this example for this. If you coerce the victim for touching the victim, and finally you able to touch that victim, and then the victim jumps out to a hole, and what happened on that time if the victim if the both of the legs of the victim were like badly damaged, or I say it's not that much damaged, but if there's scar and if one of the leg has been broken, then you can say that your battery caused the actual bodily harm. So turning on the definition of the actual bodily harm, you will find from the CPS guideline that the fact that there has been a significant medical intervention and or permanent effects have been resulted is to be taken into account when deciding whether to prosecute. So ABH on its very nature can be considered as the injury which is permanent, not like battery. So if you punch the victim, and what happens is that the victim suffer some a minor pain, then it will be considered as battery. But if you then punch the victim so hard that he suffered black eye, and then you can say that it's an injury of a permanent nature, then you can term this as actual bodily harm. DPP versus Smith, we should consider this case. In that case, it was said that even cutting the ponytails can be considered as constituting an ABH. But you should bear in mind that in that case, what the defendant did he cut the substantial part of the victim's hair. So the court say that if you cut the substantial part of a person's hair, then you have caused the injury which is permanent in nature. Because as you have already know that the hair, they are tissue and they are part of your body. So it can be said that he has damaged, his damage is permanent in nature, so it can be considered as ABH. But if you consider this with this example which I will give you now, say for example you have pulled out two of your friends' hair. So what will happen in this scenario, in this kind of fact, is that the court will say that there's a battery which has been occurred, and there is like no substantial damage or no like permanent nature of damage which was occurred in this scenario. So the court will say that there is no ABH. But what happened is that there was a battery. So now we will look at the crucial part which I have already demonstrated earlier, the occasion requirement of the section 47 of the Offences Against the Persons Act. You will find that ABH must be occasioned by the assault or battery. So what you should do is the assault on battery, and your assault or battery should cause the victim to suffer actual bodily harm or an injury of a permanent in nature. So auction here just means the same as cost. A good example is the robber's case, and I will say that the most appropriate example. In that case, the defendant made indecent proposal to a woman in his car. The defendant was a taxi driver. He was trying to touch that victim, and what he did was in what he did in that present scenario was that he did an indecent assault, and in that case, the court said that the defendant had assaulted her. But you should bear in mind that in that case, the victim jumps out of the car and the car was running on a 20-mile-per-hour speed. The victim suffered an injury which was permanent in nature and which can be termed as as you'll find from the CPS guideline that permanent nature injury was an ABH. So in that case, what the defendant argued is that he did a battery or a indecent assault or an indecent assault. But the court said that as the victim has suffered an ABH and your battery caused the ABH, so you will be liable under section 47 of the Offences Against the Persons Act. You should bear another point in mind that in the case of Savage and Permenter, and also on the subsequent cases following this, the court said that the verdict of assault occasioning actual bodily harm may be returned upon proof of an assault together with proof of the fact that the actual bodily harm was occasioned by the assault. The prosecution are not obliged to prove that the defendant intended to cause some actual bodily harm or was reckless as to whether such harm would be caused. So for section 47, the most specific thing you should bear in mind is that defendant should not have the intention to cause ABH. What the defendant should do, he must have the intention to cause assault or battery, or he must be at least reckless subjectively as to causing assault or battery. If we now consider grievous bodily harm contrary to section 20 of the OAPA, the first thing I will suggest to you is that, as many of the students have already questioned me on the class, that this kind of offense, it's termed as grievous bodily harm, so it can be occurred only by doing GBH. The answer is no, you are incorrect. The reason behind this is that the name is grievous bodily harm, but you can do it both by doing wounding or causing wounding or inflicting GBH. So if we can now turn on to this offense and consider it on part by part, we'll find that section 20 says, whosoever shall unlawfully and maliciously own or inflict any GBH upon any other person, either with or without any weapon or instrument, shall be liable to imprisonment for a term not exceeding 5 years. So if we now try to distill the actus reus and mens rea from the definition, we will find that defendant either wounded the victim or inflicted the GBH to the victim is the actus reus of that offense, and the mens rea is that defendant foresaw, which means that defendant must have intention, or defendant must be at least subjectively reckless that victim might suffer some harm. I'm repeating, some harm. So you should bear in mind that what the defendant must foresaw, that victim might suffer some harm, and this is not that the defendant should have the intention to cause GBH or wounding. No, the defendant must, I repeat again, because I know that this is the main crucial point of differentiating between GBH contrary to section 20 and section 18, is that the mens rea point of section 20, it says the defendant foresaw that victim might suffer some harm and not GBH. So if we now consider the actus reus requirement part by part, we will find that wounding. So what we have said earlier, the actus reus is that defendant either wounded the victim or inflicted GBH. So wounding, what it requires? It requires breaking the continuity of the whole skin. So you will find two layers of your skin, which is dermis and epidermis, and if the continuity of the whole of this layer has been broken, then you can say that an wounding has occurred. So for the first thing, you should bear in mind that internal rupture, this is not a wounding, because both of the layer of your skin has not been cut. And in Waltham, what happened? A policeman was kicked in the balls so hard there was bleeding in his urethra. So what happened in that case? The continuity of the both of the layer of his balls has been broken, and this is the reason behind the bleeding. The court said that this is the extended part of your skin, and the court said that it's definitely an wounding. And if you consider now GBH, what is the meaning of GBH? The meaning of grievous bodily harm, or GBH, according to the case of Smith, really serious harm. So compare this with ABH. ABH said any injury which is permanent in nature, but GBH, you need to cause really serious harm. One question is whether the severity of the injuries should be assessed subjectively. The Court of Appeal said that in assessing whether the injuries were really serious, the impact on the particular victim should be taken into account. Yes, it will be considered subjectively, because you will consider the impact of the work of the defendant on the victim. So, say for example, what happened in Bolam case. This is a very important point and the most appropriate case example for the phrase impact of the defendant's action on the victim for constituting a GBH. The reason behind this is that in that case, the defendant was convicted of GBH for injuring he inflicted on his parents' 17 months old daughter. So, in that case, what happened is that the defendant injured a 17 months old daughter. There was a lot of bruises and scars on the baby's body, and what the court said is that even though this would have been considered as a battery if it was occurred on a 15 years old girl, but we should consider the age of the victim and its vulnerability as well. So we have considered on the Bolam case the severity of the injury, and we have considered the impact of the injury on the victim, and we concluded that in that case that there was a GBH, grievous bodily harm or really serious harm. So you should bear in mind some specific things for the subjective nature of GBH is that the psychiatrically vulnerability of the victim, the effect of the harm on the particular victim, and victim's age as well. So as we have already said, the name of the offense is GBH contrary to section 20, but it can be considered by inflicting like it can be considered by inflicting GBH or causing wounding. So we'll turn on to the main point, infliction of GBH. So for this, I will say that don't be afraid because of the word inflict, because you will not be like looking at new laws here for breaking down this term. But what you will find that inflicting is the same word as causing. It was said in the Ireland case where Lord Easton held that the words were synonymous, but that there is no radical divergence between the meaning of the two words. If we now consider the mens rea of actual bodily harm, contrary to section 47 of the Offences Against the Persons Act, we will find that defendant must intend or at least must be subjectively reckless that he may cause some form of minor harm. So I have said you earlier focus on the word minor harm. There is no need for the prosecution to show that defendant foresaw GBH or the defendant believed that he would cause some harm. It is enough that he foresaw he might. So we should consider for this for the example the fact of R versus Mowat. What happened in that case? Defendant was tried under section 18 and another man stopped a third man. In that case, defendant and another man stopped a third man and they were asking for money and they were snatchers, and what happened, they took the money, £5 from the defendant's breast pocket, and then they slightly slightly make slightly hit the defendant, the victim. And what happened as a result, defendant struck him. As a result, the victim knocks down has been occurred, and as well what happened, defendant victim suffered really serious harm, because in that case, as we have seen from the Wilson's book, that in that case really serious harm has been inflicted on the victim. When arrested, defendant was found to have a £5 note in his pocket. Defendant argued that he had only foreseen some harm befalling victim, not GBH. But here is the point. The court said that what you should do for be liable to be liable under section 20 is foresee some harm befalling on the victim, and you have already satisfied the requirement. So the Court of Appeal said that it was enough to show that defendant's act which caused injury was a direct assault which any ordinary person would realize was likely to cause some physical harm to the other person. So in that case, if we consider this now briefly, we will find that the defendant just pushed the victim, and this occurred like like a really serious harm. And the court said that as you have pushed, struck him and knocked him down, you have you are subjectively reckless that some kind of harm will befall, and therefore it is sufficient for constituting an offense under section 20 of the Offences Against the Persons Act. Now we'll consider the case of savage implementer, and this case will not add anything. Rather, it will say that the specific thing of assault occasioning actual bodily harm, GBH. Here on the one third you have seen that ABH is like injury of a permanent nature, and GBH is an injury, or it's a really serious harm, injury of a really serious harm. But the thing is that both of these offenses, and as well like assault, can be committed by inflicting psychiatric harm or causing psychiatric harm. So for GBH, it must be proved either that defendant intended or foresaw his act might cause physical harm to another person or psychiatric harm. So as you have made it clear that is it sufficient to prove defendant intended or foresaw the risk of some physical harm or must be intended or foresee either wounding or GBH. I know that you know the answer, but the thing there is that I'm repeating. If you don't get me earlier, I'll say the thing is that we need the intention or subjective recklessness as to cause some harm. It is enough that he should have foreseen that some physical harm to some person, albeit of a minor character, might result. So some harm is can be substituted for the word minor harm. So we will consider an example under this. So say for example, if a husband tells his wife that he has an affair and therefore if he suffers serious depression, would the husband be guilty of an offense under section 20? What is the answer? Uh, some of you might think that no. The answer is no. But the thing is that yes. For this specific kind of situation, we will focus on Ireland Busto case, where it was said that really serious harm, it also includes psychiatric harm or psychological harm. Following Ireland Busto, the answer seems to be yes. For section 20, you need an actus reus of GBH and the mens rea is of some minor harm. So if you say your wife and she is very much emotionally attached to you, I think that what I think that definitely he will suffer severe depression for that and recognize psychiatric illness. And I will suggest to you don't try this at home. And then we will consider wounding with intent contrary to section 18. Here section 18, you can see section 18 from the slide share. I will not go through this, but if we try to distill the actus reus and mens rea from that offense, we will find that the actus reus is that defendant unlawfully wounded or caused GBH to any person. For this, I want to add that caused is the same meaning as inflicting. It is said in a case which we will consider next, but the thing is that you should bear in mind that the actus reus requirement of section 18 and section 20 is same. So this is the beauty. You don't need to go through any other laws or any other case laws, or you don't need to read Wilson again and again for the actus reus of section 18. If you cover these under section 20, it is enough that because section 18 and section 20's actus reus is the same. For the mens rea requirement, what you should establish. What is the mens rea requirement under section 18? You can see from the slide here the defendant intended or caused GBH or defendant intended to resist or prevent the lawful apprehension or detention of any person. So someone will say that GBH can only be committed if there is an intention to cause GBH or at least an intention to inflict wounding or cause ending. But the thing is that I'll say to you, GBH has two aspects of mens reas, and if you satisfied either of these, the mens rea requirement under the GBH or with intent contrary to section 18 will met. So firstly, consider the first part of the mens rea. So for the first thing, you should bear in mind that defendant must have intention to cause GBH or wounding. You have already considered the requirement for constituting a GBH, and it said that GBH means really serious harm. So defendant must have intention to cause really serious harm to the victim, and if it is some harm or if the defendant was reckless, then it will be considered under section 20, not under section 18. Say for example, what the defendant did. Defendant smashed victim head with a iron bar. So what the court will say in this specific scenario as he had the intention to cause GBH as he was trying to strike the victim with an iron bar. And if he finally like smashed victim's head and GBH occurred, the court will say you should consider section 18 because the intention requirement has been met. Consider the second part of the mens rea of section 18, which is the alternative to first part. So you can satisfy the first part or you can satisfy the second part. Take an example from me for this. Like if you say the defendant was running in the street and a man behind just behind him was following him, and what happened then? The defendant, the victim, he touched the defendant, and the defendant he made as he hold the victim's hand, and then as a result the victim falls on the road and the car smashed the victim. So what would happen as in this scenario? You will say that touching one's hand, so it is not sufficient for for the intention to cause GBH. But the thing is that if our victim is a police officer, and what the defendant was trying, if he was trying to prevent or resist a lawful arrest, then we can say that in that specific scenario what happened was an offense under section 18 and not under section 20 of the Offences Against the Persons Act. The reason behind this is that you either need intention to cause GBH or you need that defendant intended to resist or prevent lawful arrest. And if the defendant has this mens rea of resisting or preventing a lawful arrest, then it is quite clear that he will be liable under section 18 if the victim suffered GBH or wounding. As I've made it clear to you, but I will now go through this in a very briefly. The core mens rea is that defendant intended to do some GBH. The mens rea requirement for section 18 is then more stringent than section 20 in 2s. Firstly, bear in mind intention, not recklessness. Secondly, intention is to GBH, not foresight of some minor harm. If it is a foresight of some minor harm, then it will be considered as a section 20 offense, not a section 18 offense. And then bear in mind that even if defendant did not intend GBH, he can be convicted under section 18 if he was intending to prevent or resist lawful arrest. So it is necessary to show defendant was subjectively reckless or Cunningham reckless, or defendant intended to resist or prevent apprehension of any person. If the apprehension was unlawful, then the offense is not made out. Part of the offense is that defendant is resisting lawful arrest. So you should bear in mind, and I'm repeating this because this is the most crucial part of differentiating between section 18 and section 20, that intention, not recklessness, the first thing, and secondly the intention is to cause GBH or wounding, and thirdly if you can't satisfy the requirement of intention, then you should bear in mind that if the defendant has the mens rea to prevent a lawful arrest or resist a lawful arrest, and as a result a GBH occurred or wounding occurred, then the defendant must take liability under section 18 of the Offences Against the Persons Act. Now I will go through some specific scenario, and this is very interesting for you guys. This is the transmitting disease, and for this firstly I will start by go through the case R versus Dika. What happened in that case? Dika, knowing he was HIV positive, had consensual sex with two women who both contracted HIV. Defendant was charged with 2 counts of inflicting GBH contrary to section 20 on the basis that he had recklessly transmitted the disease to a woman who did not know he was infected. So in this type of scenario, what we should consider is we should differentiate between two specific types of cases. Firstly, where the victim knew that the defendant was HIV positive. On the second scenario, you should consider that where the victim doesn't know that defendant is HIV positive. So if the victim knows that the victim is HIV positive, and even then she gives consent, then we can say that there was an informed consent involved. An informed consent is a valid defense for a HIV positive patient for a liability under Section 20. But consider the second example where the victim doesn't know the defendant has HIV positive. So in that scenario, even if the defendant said if she knew, she would have given me consent, but the thing is that the court will say that it's not the informed consent which has been given in the present scenario. So you cannot argue that the defendant will not be liable. Rather, as it is not informed consent, the defendant will be liable under Section 20 of the Offences Against the Persons Act. So consider this principle very sincerely. Consent to sex itself could not constitute consent to the risk of disease, but it is valid defense to GVH for defendant if victim does consent knowing that defendant had HIV. So this is the point of informed consent. What the court said in the case of Dika, mainly Judge Lord Justice who presided this case on the Court of Appeal, he said, as a general rule, unless the activity is lawful, the consent of the victim to the deliberate infliction of serious bodily harm on him or her does not provide the perpetrator with any defense. Categories of what lawful activity are close or imminent. So I will now give you two examples and consider it very sincerely. On the first scenario, we have a Catholic couple who won't use contraception, but one has HIV. If the law prevents consent to risk of transmission, it would force them to choose between sex and the risk of criminal liability. But consider the second scenario. A couple desperate to start a family. The woman is told that giving birth would present serious risk to her health, but they run that risk. If she becomes ill, is he criminally liable? For both of these scenarios, consider this that for if we criminalize the sexual activity of HIV positive patient, then it will be inhuman and as well it will be against the Human Rights Act. The reason behind this is that if there is informed consent involved in a scenario, then we cannot say that there or this what was inflicted on the victim was a crime, because HIV positive patient has every reason and has all the rights to start their family, to do sexual intercourse, and it will be very inhuman to suggest that they don't have the right. But consider this example with the Dika case where the defendant knew that he was HIV positive. He he becomes sexually involved or penetrated. He do the penetration with he does the penetration with three victims, and all of them inflicted HIV. So what happened in on that scenario? On that scenario, you should suggest that there was no informed consent, and it will be very unjust for the victims as well to not to criminalize this type of behavior. And that is why on Tika case what offense occurred was a Section 20 offense, and in this scenario where the victim knowing that the defendant has HIV positive and she gives consent, the court will say that in this kind of scenarios there will be no offense because there was an informed consent involved. Criminalizing sex here would have adverse impact on public health as well. I think it's very interesting for you. It was very interesting for you, I think. And we'll now consider the Konzani case, where the doctrine of implied informed consent has been considered. In that case, defendant knew he was HIV positive but repeatedly had sex with three victims without informing them of his status. As the same case as Dika, all of them contracted HIV. The court said that defendant was charged with GBH, and the court said that defendant was not to be convicted if there was informed consent by the victim to risk of HIV. But the thing is that if defendant concealed his HIV from victim, that concealment automatically means that she was deceived and could not give informed consent. So in that scenario, considering the public policy and as well considering the inhuman nature of criminalizing the HIV positive patients' right to do sexual intercourse, the court said that in that scenario, what happened was a Section 20 offense. The reason behind this is that there were no informed consent. So what would happen in that case if all the victims, they knew that the defendant is HIV positive and all of them then gives consent? Then the court would say that there was no Section 20 offense because there was an informed consent involved. And if we say that in this type of scenario it is we term this type of scenario as Section 20 offense, then it would then have been considered as against the public policy, public health, and as well inhuman behavior. Summary: if we make a summary of the points we have already considered under the transsexual transmitted diseases, we will find that it is clear that a partner can consent to risk of HIV transfer if she knows that defendant is HIV positive, but this consent must be informed consent. And from the what I have suggested to you or demonstrated towards you, you have already, I think that you already know what is informed consent is. And this is based on the fact that it would place too great a limit on person's autonomy to limit to freedom by denying the ability to consent. If such a limit is to be imposed, that is for parliament, not for the judges. If defendant is going to raise a defense that victim consented to HIV transmission, he need to show that some evidence of an honest belief that the complainant were consenting to the risk that they might be inflicted with HIV. Now we will consider the specific kind of scenarios, consent and assault. So whether consent can be considered as a defense to the criminal liability of non-fatal offenses. For this, we should consider the case of Brown, where where a very dangerous group, which is termed as the most dangerous group in the UK, which is the shadow machinist. They believe in a concept that the machinist should do torture on the shadows, and they do this for sexual pleasure. In that case, the prosecution for the shadows, they suggested that the defendant or the machinist should be guilty of section 18 or section 20 or section 47 at least. The court in that case said that the defendant's lawyer or barrister's argument before the court in both in this case was that all the victims were giving consent and none of them were trying to file litigation against the defendant. So how can you say the defendant committed an offense? However, the court said in that case there is no public policy involved to not to term this kind of behavior as GBH contrary to section 20 of the Offences Against the Persons Act. And therefore, in that case, the court make a very clear line for the operation of consent defense for all kind of non-fatal offenses. What the court said, if we now consider these, we will find that the law after bound heading is that consent of victim is defense to assault or battery. So this is the only two offenses considered as non-fatal offenses which can be termed as legal if consent has been given by the victim. So it is said in the case of Collins versus Wilcox, which case we have already considered earlier, the policewoman's case. But the court repeated and again said on the case we have considered just earlier is that it is not a defense. So consent is not a defense to ABH or GBH unless the case falls within the following recognized categories which are created for public interest. So the first is the sports activity. So take for example boxing. If it's a formal match, then you can say that if the defendant punched the victim on face and then the victim suffered black eye, you cannot say that this is an ABH. The reason behind this is that this is a sports activity, and for this kind of behavior, if we criminalize this kind of behavior, then Mike Tyson, there was a famous boxer who would have been charged for section 20 or section 18 for more than 100 times. The second exception which created for the public policy reason and for this type as well, consent can be a defense, is dangerous exhibition like circus. For rough horseplay, surgery as well. For surgery point, I want to add something. The thing is that for surgery, you can consider this example for the illustration. What is the public interest involved in this type of cases? Is that, say for example, a patient who when a pregnant patient who went to the hospital and then he become unconscious, if she becomes unconscious, then the doctor have to decide whether he want to permit cesarean on that woman. And if after getting consciousness, the victim said, "Whoa, what happened? I was expecting a normal delivery and you have performed a cesarean on me without taking my consent," the court will say that you cannot say that. The reason behind this is that the doctor is the person who is working for your welfare and for the public interest, for all the patient he is supposed to treat, and for this is clearly a valid defense. So consent is defense for surgeries, tattooing, religious surgery like circumcision, and consensual infection like, as we have said, if there is informed consent, then it will be assault for or transmitting. It will be a defense for all kind of STDs. So bear in mind that these 7 categories, these are not the exhaustive list. So if the court is persuaded that the defendant conduct is beneficial to society, a court may be persuaded to create a new exceptional category. So do you think that all the kind of prank show, they should be like listed in this category? I think that this is a matter of consideration as well, and we should now wait for the House of Lords to consider a very specific case, which I will able to demonstrate to you if any kind of new public interest ground has been created here for the prank shows, and then I will illustrate this point to you. But wait for the House of Lords. I think for till 2020 at least. We'll consider now a tattooing case, which is R versus Wilson. Here, a defendant he branded his initial on her buttocks of her wife's buttocks with a hot knife. What the court said that it is a permanent nature of injury. So, if we follow the definition as well and as well the CPS guideline, we can say that this is an ABH contrary to Section 47. But what the court said in that case, the court said no, this is not an offense because this is the emotional attachment which the defendant was expressing towards his girlfriend or wife, And so if we criminalize this type of behavior of tattooing in the home, then we should as well criminalize the tattooing which were done on the shops. So as we have already created public interest ground for consent to be operated as a defense for the non-fatal offenses, and we created the tattooing type of situation as a we in as a on the list, so we can, as an exception, so we can say that this type of behavior should not be criminalized. And I'll say again that don't try this at home. So now we'll consider one case which is a very recent, not very recent case, like it was occurred in 2010, age versus CPS. So consider two examples. The first one is informed consent, which you have already considered under the sexual transmitted disease, and implied consent, informed and implied. So if you say for implied consent, we should consider the case of H versus CPS. Here, a young student was suffering from ADHD assaulted a teacher in the playground of his school, designed for a student with special needs. In that case, the defendant argued that the teacher had impliedly consented to such violation from a student by working in that environment. But what the divisional court said, divisional court completely rejected this argument of the defendant's lawyer. He said that there is no concept of implied consent. What we have for the best is informed consent. So the employer, they need to tell the employee that if you work here, you might suffer some kind of harm. You can expect that some student will hit you or beat you, and if they don't say this kind of thing to their employee, they cannot at last say that you have given us implied consent, so you will be liable. The court will say that, as in here in the divisional court has already said that this argument will not work for you, because here no implied informed consent has been given, and what was given was the implied consent, and the defendant are expecting this consent to use, but the court will say that there is no concept of implied consent. I think that found the class very interesting, and this is all for non-fatal offenses against the person. And we have already considered 5 types of offenses, and those are assault, battery, ABH contrary to section 47, GBH contrary to section 20, and GBH with intent contrary to section 18 of the Offences Against the Persons Act. So now you should try to solve the activities on the subject guide, and then you should follow the instruction which was given for part A by the University of London, and then choose the questions from the examiner's report, make 5 or 6 sub questions under that, and then try to answer. It will be very much helpful. So take for like on the 2018 question, you can say on the bottom that what should be the prosecution's argument, what should be the defendant's argument, what is the defense which should occur and which should be raised in the present scenario. This should be this is another type of question, and then you can say that whether the defendant will be charged under section 18 or section 20. So make subparts of the question on the bottom, and then try to answer the subparts from the fact of all the questions contained in the examiner's report. This will be very much helpful rather than waiting for your register center or University of London to publish another instruction, which I think will not be given because your exam is very near, within 10 days, 10 or 12 days. So try not to wait for the university or your register center. Make your own questions and then try to solve it. Firstly, start with the activity contained on the subject guide, and then you should jump to the questions and make the sub questions which how I have suggested to you. Thank you all. Thank you very much for your patience.